Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 63 of the NCDWI Guy podcast. On today's episode, we have Steve Lindsay, who is going to be talking with us about closing arguments. Today's episode, we're finishing up a 5-part series that is kind of worked around attacking the breath tests. Back on episode 59 and episode 60, we talked with Andy Ewens, a toxicologist who went through the science behind breath testing, as well as a look under the hood of the ECIR2 device. On episode 61, we spoke with James Nisi, who explained the multiplication factor when it comes to the sample chamber used in the device, as well as then how it's correlated with the reported alcohol concentration in 210 liters of breath. And then on episode 62, Matthew Davenport was on to talk with us about the language. What does it mean for the result to be deemed sufficient? And how do we attack that in the jury instructions? And how do we overcome that deemed sufficient language when it comes to breath testing? So on today's episode, we have Steve Lindsay. Steve has been involved in a number of high-profile cases, high-profile murder cases, but he's also tried all kinds of different charges, including a ton of DWI cases. Steve, outside of the courtroom and outside of everything that he's done in the courtroom, has really been both a student and, more importantly, a teacher when it comes to the law and helping to educate lawyers. Steve devotes between about 6 and 8 weeks a year to training programs, lectures, and keynote addresses. He is a faculty member at the National Criminal Defense College. He's been that since 1996. At the Defender Advocacy Institute at the University of Dayton Law, at the Federal Defender Trial Skills Institute, and at the Institute for Criminal Defense Advocacy. Steve has published a number of articles on criminal defense and how to kind of incorporate these skills into the courtroom. And I had the pleasure of seeing Steve give a amazing CLE down in Henderson County about 2 years ago on demonstrative evidence, which was far and away one of the most entertaining CLE hours that I have ever seen. Changed my view of demonstrative evidence. And Steve, it's an absolute pleasure to have you on the podcast today.
Well, thank you, James. It's a pleasure to be invited, and I'm looking forward to spending the next hour or so with you.
I'm excited about it. Yeah, we're going to kind of spend some time talking about closing arguments. And again, a lot of these skills that we'll talk about today are going to be applicable within a DWI trial, outside of it, applicable in terms of no matter what you're kind of attacking on a DWI case. But I guess in terms of closing arguments and trying to set that up properly for the jury, talk to us a little bit about the importance of a closing argument and kind of what your mental framework is for the closing.
You know, there's been just a ton of stuff published about closing arguments. I remember a great lawyer telling me one time, when you're going into closing argument, you have 3 kinds of jurors out there in front of you. You've got those that are for you, you've got those that are against you, and you got those that are on the fence, right? And so your goal is then not to give the ones that are against you any more ammunition than they already have.
Right.
And you want to give ammunition to the ones that are for you to help them be strong. And the ones that are on the fence, you really want to try to sway them in your direction, if at all possible. Unfortunately, we don't know who's who a lot of times, because the visual signs we get from our jurors are not necessarily helpful. They, some of the jurors that look at you and smile and nod their head hate you. It's
Right,
just
right.
it's funny. You find out after the fact. You're sitting there, you're hoping, you're saying, God, if Mrs. Jones will just stick with me, and then you find out, you talk to the jury afterwards, and they go, we would have been done a whole lot quicker if Mrs. Jones had just been willing to vote with the other 11 of us.
Yeah, I think for me that's a particularly like problematic point. I'm really not good at reading like visual cues when my wife is trying to like send signals to me from across the room. Those are like completely over the head. So that's
Absolutely.
not a help point on my end in the jury selection process.
Yeah. So, and I guess maybe that's true in general. I think that there's some things to really think about, and that sometimes lawyers confuse when it comes to closing arguments. And one is, what is a closing argument? And how does it differ from an opening statement? Because so often I see lawyers just repeat what they said in their opening, and obviously there's got to be more to it, than that, and there is more to it than that. And the other thing is remembering that the closing argument isn't given in a vacuum. We've led up to this point, and so if we haven't really done a good job of picking our jury, we're really behind the eight ball when it comes to a closing argument. When we haven't marshaled the facts from the witnesses along the way that we need to pull out to use in our closing argument, then we're not in a really good position to do a closing argument. So, each of the steps along the way builds to that point, that apex, that climax, if you will, of the trial, where you get to stand in front of the jurors and talk not at them, but with them about not just what your story of innocence is, but how the facts that the witnesses have brought to the table, that you've so carefully pulled from them along the way through cross-examination or through direct examination, how those facts prove that your story of innocence is accurate, that it's the right one, and it's the one that the jury should vote for. So it's all a process that leads forward, and it starts with a good theory of defense that has to be something more than the defendant is not guilty because there's a reasonable doubt that blank, right?
Right.
So what you're going to start with when you create a theory is you understand that the theory of your case has facts, right? There's three components to it: the facts of the case, and those are the facts you get through discovery and you develop through your own investigation. There's a legal engine that drives this, right? This is why the defendant legally is not guilty. And then there's got to be some emotion to it, James. It's just, emotion. I'd really almost rather have when you think about jurors, right, in their back, they're arguing. You got the intellectual ones back there who've decided maybe that intellectually you're right, between their ears. But the problem with people that think about things only intellectually is they kind of operate from this position. Well, intellectually, this makes sense to me, and I'm going to continue to vote this way unless intellectually I can change my mind. So they're willing to listen, to alternatives. Now, people that are emotionally tied to the case, and if you can get to their heart, as in addition to this right here between the ears, you can get to their heart. Those people will pick up anything sharp and cut somebody if they get too close to them and try to challenge them on how they feel.
Right.
And if they feel that your client is innocent and somebody is really pushing them, they're going to say, back off. And you can sometimes hear those kind of jurors back in the jury room screaming at each other because you've given them some emotional power to say that they're right. And so we want emotion,
I think that's one of the things that a lot of times also can separate the defense from the prosecution, because the prosecution, generally speaking, in a lot of closings that I've seen, the DA stands up there and gives this very almost kind of formulaic closing argument without much emotion. And so, it's actually a relatively easy to distinguish yourself from that kind of presentation style, and I think can earn some amount of like kind of emotional feedback from the jurors, because they're really not going to be getting that from the state during that closing.
Yeah. Oh, agreed. Wholeheartedly. I absolutely agree. So, I think so. Those are the things you want to think about. Let's talk for a few minutes about the real differences between opening statements and closing.
Yeah, absolutely.
A lot depends upon the judge that is presiding in your case, and because different judges have different opinions about how much they'll let you do when you're talking with a jury. But the difference is the opening statement is supposed to be a projection in some ways, a roadmap, if you will, of where you think the case is going to go. We don't need to be spending any time saying anything about, well, if your memory is better than mine, you blow. No. We just want to tell them a story. Okay. We just want to tell them a story. And I think sometimes lawyers in openings, it's not supposed to be argumentative, but when you put it in the form of a story, it is argumentative without it seeming so. So it comes in that way. I think in the opening, we do want to encourage a position. We don't want to be sitting around and wasting our time, but we want to tell them what the story is, and we don't want to confuse length with substance, right?
Right.
Short is sometimes better. And so my experience is in the opening, we're going to do an opening statement that plays off of the questions you've asked jurors during jury selection and some of those things we've sought from them, but introduces them to the facts of the case in story form, right? But it doesn't go into great depth. You do not want to be factually intensive in your opening statement. The jury is just not ready for that much information at one time.
Yeah, and I've seen that prove also problematic where you kind of lay out the specific facts, and then for whatever reason, a real critical fact doesn't get introduced or come out during the testimony or evidence or however it might play in, maybe to your benefit or maybe against you. But even if it's to your benefit, it's kind of like, well, we heard from the defense attorney that we were expecting this piece of evidence to come out, even though it never came out.
It never came out. Yeah. And so you don't want to make any real promises that you can't keep, but you don't want to bore them either. So you're going to give them an overview of your case in story form, right? Then along the way, when you're cross-examining the state witnesses and you're deciding whether you're going to put on evidence, and you say you do, you want to put things in that are information that proves then, or you're going to use in your closing argument to show that the story that you told them in the opening statement is the right one, is really accurate, right? So you're creating these building blocks, if you will, from the various witnesses, so that when you then get to the closing argument, your job in the closing is to not just reiterate the story that you gave in the opening, but marshal up the evidence that you have so carefully taken your time to develop and show how that evidence proves that this story that you told them is right.
Right.
And then you want to bring them around and challenge them to do the right thing, empower them to do the right thing, which is either find for a lesser included or find not guilty, depending on the charge that you're defending. So that's really the difference. The difference is then in the closing, you're marshaling up the evidence and you're allowed to be argumentative, boldly argumentative, as opposed to sort of passively argumentative in your opening statement. And not only can you argue the evidence, but you can argue any reasonable inference that can be drawn from that evidence. So you're not just stuck with what came out in the courtroom.
Right.
You can even answer certain questions that you pose to the jury. So why would someone do something like this, ladies and gentlemen? Let me tell you why.
Yeah, that's great.
A couple of reasons why that never came into evidence, but it's a reasonable inference from the evidence that you can argue, right? That you can present. So, when we're talking about closings, James, there's two main components to it, and I liken it to sort of music in some ways. And if we think about it this way, we all have a favorite song, right? And for me, one of them would be Eric Clapton's Layla, right? The original Layla, not the new slow one, but the slow one. And so, if you were to ask me, what is it that makes Layla my favorite song, right? One of it is the words, right? It's the lyrics. And if we liken that to what we do in closing argument, right? It's what we choose to say, the words we pick to deliver to the jurors, right? But two, the other thing I really like about Layla is Clapton, the way he sings it.
Right.
If we picked somebody else, and a lot of our people listening probably don't know who Don Ho was. Don Ho was the guy that sang Tiny Bubbles and, had the ukulele and sang Hawaiian music, right? And I didn't like him at all, even with the songs that he created. But if you put Don Ho singing Layla, it'd be awful. It'd be absolutely awful.
Yeah, be worse than a different song, right? Like you'd actually kind of be viscerally like disgusted with.
Yeah, you would. And if we take that lesson then into closing argument, there is the song that you choose to sing, the words that you want to say, and how you choose to sing them, And so those two things come into play in dealing with juries and closing arguments, whether it's a DWI case or it's a murder case, right? The same rules apply. Can you connect with this jury, right? So
just, I guess, to touch real quick on that, Steve, in terms of kind of connection between opening and closing statements, the purposes of both of them. I've talked with attorneys that kind of take different approaches when it comes to when they prepare the closing argument. Do you kind of let everything play out, hear it, and then kind of have your closing argument crafted as a response to the evidence? But it sounds like you are, kind of suggesting more in the approach of kind of begin with the end in mind, right? If you kind of know where the evidence is going to go, kind of forecast, how you're going to bring out your story that you're going to then kind of develop through the actual evidence and then kind of deliver to the jury in argumentative format from the beginning.
Yeah.
Yeah. So, and I think that's important. I do think that especially, maybe particularly with regards to a DWI, but again, I don't know, maybe any case, if you know how the evidence is going to come out, how it's going to kind of be brought through, if especially you tried the case already once at district court and now you're up in superior with the jury involved, you've got a pretty good idea of how the state is going to answer questions, where the case is going to go. And so, why not have that kind of fully prepared and be kind of moving towards something?
Well, I think where the difference comes is that if you have a theory of defense and you have created a story, right? The notion of story form defense versus pure reasonable doubt defense is that in a reasonable doubt defense, the defense lawyer sees their job as basically destroying every witness that the state chooses to put up, right?
Right.
And their goal then becomes trying to prove that they lose, that they're wrong in some way, right? Unfortunately, that puts us in the position of defending by cross-examining witnesses because we can and not necessarily because we should, right? And it leads to sort of an aggressive nature a lot of times that doesn't really jive with the jury's view of what should be going on here, right? So instead of that, if we have a story of innocence and it follows this line, and the state's story of guilt follows this line, right? Understand that these two stories have to intersect somewhere, or we wouldn't be in the courtroom, right?
Yes.
And so oftentimes at that intersection point, the state focuses right there on that intersection. And if we can't get the jury to broaden its perspective, you're going to lose, right? Because it's the seconds when the gun was fired and the person was killed and the awfulness around the crime scene.
Right.
If you can expand your horizon out and get the jury to look at a bigger picture, right, then it recasts that cross right there, and it gives them a different perspective than what the state's perspective is of what actually happened here.
Yeah, and I would say, again, just in regards to DWI, and we've been talking about breath testing, I think that in a DWI case where you have an alcohol concentration and that's coming into evidence, you're going to try your pretrial motions or whatever it might be, but if it gets to a jury, the number's coming in and you kind of are able to expect that. The primary witness of the state is a machine. It's not a person. And so if you can kind of expand the jury's horizons in terms of how trustworthy is this device, right? By telling a different story about the accuracy of those results, Now, I mean, maybe there's some issues in terms of how the trooper did the investigation or the witness that came on scene. But really, at the end of the day, that's not the focal point. Now it's kind of, is this machine a trustworthy witness? Because that's who the state is offering to you as the reason for conviction.
Sure. And so any story that you can utilize that brings that into play, right, is helpful. And we'll talk about a few of those. If we have a story of innocence, though, it changes how we have to handle the cross-examination of their witnesses.
Yes.
So instead of taking on a trooper about how terrible he is or she is, right, or how crappy their investigation was, although that is one direction we can go in, and we'll talk about that in a minute. But if we can focus more on what does this witness have to say that can help us,
right,
versus how can we hurt them, then we're ahead in this game. We don't have to treat all the witnesses if they're enemies, right? It's my analogy is if the state's case is Coca-Cola and our state is Pepsi-Cola, if as Pepsi, I can get Coke to say, you know what, Pepsi's a damn good drink.
Right.
I'm way ahead, right? I'm way ahead. And so I want people to start thinking in terms of what does this witness have the potential to say if I'm just smart enough to ask them the questions that are going to help me prove to this jury that my story is the right one, right?
Right, exactly.
To this, then we're far better off. So, let's think a little bit and talk a little bit about, some of the ways that we're going to be setting up for closing argument in a DWI case, right? What are some of the stories that we can use, and what are some of the things that we can do to prove, as you pointed out very accurately, there's a machine that is basically the primary witness against us.
Exactly.
It's also a machine that can't talk. So how do you cross-examine a machine? It's kind of like cross-examining a drug dog.
Right. It is.
Search,
yeah,
right?
exactly. That's a good example.
Yeah. I mean, how do you, really? I think it's important in DWI cases, and this is probably really, really basic, and most people have thought about this, but let's think about a couple of things that are important for us to have in the form of a juror, right? What kind of jurors do we want? Obviously, what we don't want are people that are just categorically opposed to alcohol.
Right? Exactly.
We probably don't want people who have had a family member who's been killed by a drunk driver, right? I mean, there's certain types of folks we're fairly certain that we don't want. But we need to be able to identify who these people are in some ways during jury selection so we can move away from them. If you were going to get an ideal witness in a DW or a juror in a DWI case, what would their attributes be?
Yeah, I think that there's a number of different approaches. I think it could somewhat depend on your theory of defense, as you were just talking about. So if you want to take the kind of approach of, I'm going to try this case by the standard of beyond a reasonable doubt, you want the analytical people on the jury, right? You want the people that are able to kind of understand that distinction and understand that even if I think it's likely that this person committed this crime, that's not what the state is required to prove. So kind of like that high intelligence person, maybe, and maybe you could speak to this in a situation where you're kind of approaching this from a innocence perspective and kind of building that story through it. Maybe there is a kind of a higher focal point on the person that is kind of emotionally connected to this situation, less trusting of machines, is not somebody that is kind of all bought into technology and all those kind of things, that just says something doesn't feel right. If I see somebody that's on video that is talking, acting, walking normally, and then, there's a machine that says a 0.20, there's some sort of a disconnect here that is going on.
Right.
But again, is that something that you focus more in terms of kind of the emotional connection of the person a little bit?
Well, it's interesting. I think that we have a tendency during jury selection. First of all, I think jury selection is the thing that makes most trial lawyers anxious,
Yes.
right?
Yep.
Because you're talking and you think because you've had this lawyer training, you got to talk, and you're not doing a very good job of listening most of the time.
Yes.
And so,
I would say at fault in my particular
Yeah.
situation, especially early in the career, was I tried to use the jury selection as a teaching opportunity for, kind of how the evidence was going to play out. Like, if this evidence comes out this way, would you be still comfortable returning a verdict of beyond a reasonable doubt, and asking a lot of these like yes and no questions, and just, it was very one-sided in terms of the conversation.
Well, and a lot of the questions that we ask too is we're asking them how they're going to behave in the future.
Yes.
If you're on the jury, how are you going to behave in the jury room?
Yes.
It's like saying, if I put you on the jury, will you be fair?
Right. Yeah.
Life's experiences tell us this, James. It tells us that what people say they're going to do in the future isn't a very good predictor of what they're going to do in the future, because things change. And so asking those kinds of questions doesn't really help us very much. So if we can find out more about the past and how the jurors have behaved in their past on issues that are important in this case, then it puts us in a better position to predict how they're going to behave in the future, because history repeats itself.
Yes.
Have you ever noticed this? You get into it, you're in a relationship with somebody and you break up because of X, and you say, I'm tired, I can't deal with you anymore because you're too X, whatever it is, right? And so you break up. And you know what? The next person you get together with is exactly the same. They're exactly the same. And within a short period of time, you get right down to the same point again where we got to break up because, you know what? I don't like the fact that you're X.
Yeah.
And we're creatures of habit. So if we can find out how the jurors have behaved in the past with regard to important issues in this case, we are much more likely to get a favorable jury, right? When we find those things out. So we need to find out how people feel about alcohol. Do they use alcohol? Do they drink alcohol, right? We need to know how they feel about driving and drinking, even if you haven't had as much as what a breathalyzer might say. Have they ever driven after drinking? And how do they feel about that? So, we need to find people that are receptive to that, because even though we're going to challenge the breathalyzer machine, and don't call it an instrument, we're calling it a machine, right? We're always calling it a machine, and never a scientific instrument. What we want to know is that, they're not going to, it's going to come in that our person smelled like alcohol, right?
Right.
It's probably going to come in that they may have had something to drink. But, the bottom line is we don't want people to be shut down by that and say, oh, they must be guilty. We want people to say, I've been there. Doesn't mean
there's a couple of kind of a good road to go down. I think really is, when have you kind of seen machines fail? Can you describe that? Why do you think the reason was for that? One that has kind of come up to me recently in terms of just thinking about how to get jurors to think about like an immediate past experience. And I don't know how long we'll kind of be in COVID protocol, but when you go into the Buncombe County Courthouse and many other courthouses, you have to go through a kind of temperature screen check. Well, that screen check always shows me like 10 degrees colder than I actually am. And so anytime that those jurors are going through the screen check, you could say, did you show that your temperature this morning was 97 degrees, or do you think that was accurate? Why do you think that was wrong? Machines sometimes get these things wrong. So I think using those kind of common sense examples of where have you seen machines fail in the past, but then also, why do you think that there was an error there, right? Clearly this machine was designed for this particular outcome, to get somebody's temperature so that we make sure that people are safe in the courthouse. But why is it not kind of reporting this accurate amount? And that's where I think that I was missing opportunities, especially early on, is not just to point out the fact that there was an inconsistency, but then to get from the jurors their reasoning why they believe that there was that inconsistency. And no matter what that looks like, that's really where you're going to be able to hopefully get a better picture of, is this a good juror for my case, or is this not a good juror for my case? And that kind of why question.
Well, I love the question about taking the temperature when they come in, because we all get our temperatures taken. My experience has been the same as yours, that the accuracy of that is in my mind, it may be in the ballpark, but it's not particularly accurate.
Right.
And it's I sit back and think to myself, well, it's no surprise that people get through here that have the stuff.
Right.
Because, the temperature is not really accurate. And I would use that probably as a second stage or a second question of the jurors on life experience. But I like what's called life analog questions and of jurors during the jury selection process. And so life analog questions are questions that are sort of imperative superlative questions. Tell me the most significant experience in your life where you, a family member or a close friend, right, had a problem when a machine went wrong. Right. A machine that you would expect to be accurate malfunctioned in some way. Tell me about that. What happened? What did you do about it? Thinking back on it now, would you do anything differently than you chose to do then? Right. And so those kinds of questions, somebody's going to come up with a situation. Well, I had a blood test that was done when I went to the doctor, and the blood test showed that, I had, diabetes or something. Right. And it turns out that it was wrong, something. And so, but it was very upsetting. Right. Blah, 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 blah. And so, you want to talk. So I take it then you're saying, Mrs. Jones, that machines aren't always perfect. Is that what you're saying? Yeah. Did you get your temperature taken when you came in this morning to the courthouse? And tell me, I don't need to know the result. Did you think that it was accurate, right? And let's talk a little bit. Tell me a little bit about what happened. And let's talk about that experience. Why would it be important for us to know as accurately as possible what a person's temperature was coming in? Right. Even though it's important, can you see, though, how a test might fail or a machine might fail? All right. And so you can talk about those sorts of things, because you want people who are going to be able to say machines aren't perfect.
Yeah, exactly.
Say, one of the big problems you got is you can't talk to a machine. Wouldn't you love to be able to say to that thermometer when you walked in this morning, what are you talking about? 92.8. I'm 98.6, right? Yeah. Hear what the thermometer has to say. Well, I'm having a bad day today. I didn't get enough coffee this morning. But the machine can't talk, right? And so you're left to your own vices in some ways. But you want people who are sympathetic to the fact that machines are doing way too much in society these days.
Yeah, and I think by those kind of non yes or no questions, right? Like really trying to get the life experiences out of the jurors, you do two things. First of all, you allow the jurors to start a conversation before they get back to the jury room. So even though they're talking to you, they're really kind of communicating to some extent with one another. And then you maybe follow up with, Mr. Jones about what Miss Smith just said. And so, did you hear her example about this? What do you think about that? So you can kind of start this conversation, but then you also give the jurors that are on your side kind of ammunition once they go back into the deliberation room to kind of draw on each other's life experiences, right? So now they can kind of say, didn't you tell me, or didn't you say during the time that we were going through the selection process that you kind of had this interaction, with a doctor who had kind of misidentified based on a blood test. And so now, they can pull in that life experience. Whereas if you kind of just go in with these yes or no questions, will you follow the law? Will you kind of make sure that the state is held to proof beyond a reasonable doubt? They don't have that ability to necessarily kind of think to ask those questions of each other in the jury room.
Well, if we extend then this notion of this life analog type questioning to other kinds of cases, for example, if we have a case where we feel like there is some sort of a racial injustice that has gone on, that somebody was treated poorly because they were African American, for example. One of the questions you want to ask your jurors, tell me about it, the most significant, right? Because if we do the imperative superlative, then we kind of narrow the net down a little bit, and we don't get these answers that are way out there in right field, but it's just so far away they're not helpful. Tell me about the most significant experience in your life where you, a family member or a close friend, either witnessed or were somehow involved in a situation where somebody was treated unfairly because of the color of their skin, right? Tell me about that. What happened, right? How did it turn out? What did you do? You know, because you want to kind of know, did they intervene in any way, right? You know, did they step in and say, hey, this is just not fair, or what happened? And thinking back on it today, I think this becomes a really important question. As you think back on that experience today, is there anything you would do differently if you had it to do over, right? Yeah, and then you learn about their feelings about racial injustice, how strongly they feel about it, about their willingness to interact. And then you're not really telling them that that's what this has to do with this case, but you're finding out what their feelings are. And then in your opening statement, when you reveal that there's something about that, they're going to go, aha. Yes. Right? Aha. Right. And so that's what we're wanting to do with the jurors as we start thinking about how we're going to deal with the machine in terms of DWI cases. Yeah, no,
I think that's a really helpful framework for that, because again, the people so often draw on their life experiences, and then they're also kind of communicated that so many times through different courtroom players, the judge, prosecution, and the defense, in terms of, you know, using your common sense and experience, right? Like drawing on everyday experience, all this kind of language. And so, you know, if they're able to, again, point to each other, well, you know, I actually had kind of a similar situation that has come up with regards to a machine that didn't kind of produce the right way that I was expecting. Now it's easier to say, well, yeah, maybe something did go wrong in this case, because again, that the machine witness doesn't match up with all of the other witnesses that are involved on this particular situation, in terms of the individual driver not appearing to be impaired, even though his BAC level shows that.
You know, and you know, we all have experience with things start to go a little bit weird when the batteries start running down.
Right.
You've got to remember these sorts of things too. I mean, is this something that is kept in the trunk of the car? If it is, hell, we wouldn't put a child in the trunk of a car. Right. And we'll die in the trunk of a car. And so the heat and all that kind of stuff. And, you know, I don't know. You know, I mean, who had it last night? You know, somebody else. You're not the only person that keeps this machine. Right. You didn't build the machine. You can't fix the machine. This is a machine that when it breaks, you have to have some specialist come in, or like the old Curtis Mathis TVs, you had to box them up and send them back to Texas where they worked on them in-house. You know, I mean, you know, you're talking about somebody who has been trained to run a photocopy machine. Right, but exactly. Not how to fix it, right? That's basically what we've got here. Yeah. That's basically what we've got here. One of the things that's important to remember in a DWI case is this notion of, and you know, there was a case that came out not too long ago in the Fourth Circuit. I think it came out of the Western District of North Carolina. Andy brought it out in one of the things, is the Drakeford case. And one of the things it talks about is, you know, what the Constitution requires and what it doesn't allow. And what it doesn't allow is for, you know, a professional to form an opinion and then get the facts after forming the opinion to prove it up, right? And that was in the dissent, I think, but it's really well put. And it's important because one of the stories that I like to use, especially in DWI cases, relates to that very concept. And it's one that I will tell in closing argument as I have marshaled up all of the evidence along the way. And it goes to this notion, and we all can understand this. Officer is driving down the road and the car in front of him starts doing this, right? A little right to left. And the officer says, I got me another one. Yeah. Got me a DWI, and they probably even call it in. Going to pull over a DWI.
Yeah, that's right. Right. Possible impaired driver.
Yeah, and we're off to the races because the screw up has just started, right? It's just started. Because the job of a police officer is to investigate, not to prove it up.
Right.
Right. So
I call that the beer goggles going on at that point.
Yeah. So as we work this up, and there's ways to deal with this during cross-examination of the officer and laying the groundwork for the fact that you're supposed to be neutral. You're supposed to be neutral. The things that you do are supposed to help you come to a conclusion, not to prove that a conclusion that you have already rendered is in fact the truth, right? Blah, 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 blah. And the story goes like this. Many, many, many years ago, James, and one of the things, before I tell this story, it's important. Remember, we talked about what is the song going to be and how you choose to sing it. There's a couple things that are just basic things that are so important in closing arguments. One is when you are given the opportunity to close, stand up and walk to the jurors and stop. Do not say anything on the way, right? As you get up and you move forward, if you're talking, the problem is walking and talking. Do not do this. When you walk and you talk, it says, one, you're saying, I want to tell you something that's very important. But your body language is saying, what I'm saying is not important at all, right?
It's so funny that you're saying this because you talked about this during your CLE, and I had forgotten that you were the one that mentioned this. But after that CLE, I followed your advice, and anytime that I'm talking to the jury, I stop. If I move to another position, I don't say anything on the way. Stop again, address them. But that I forgot that came from you, so I put that into practice.
So, and remember that. So when you get up and as you approach the jury, shut your mouth. Get up there and just be quiet for a second and let the quiet of the courtroom just soak in, and then speak. Right? Use the space wisely. But God, make eye contact. If you cannot look your jurors in the eye, they're not going to believe you, right? We come from a society that just, you don't know how many times I have said to a client when we have gone to do an interview with a police officer, if we choose to do that, look the officer in the eye, because otherwise you won't be believed. And at the end of the interview, the officer will often say, I believe you, Johnny. You know why? Because you looked me in the eye when we talked. Right? Honest to God. But it is a way that we communicate, right?
Yeah, that's great.
One of the things that's important is that when we break down the types of learning that people do, right? We know that only about 30% of our audience are capable of listening and learning, just listening. So the lawyers that stand at the podium and give a prepared speech are only getting through to about 30%. Yes. The other 70% are tuning them completely out, right? You got then about that 30% are probably tactile. They kind of have to demonstrate a little bit and try a little bit. You need to help them understand that. And then the rest of them, the 40% are visual, right? So you've got to be able to help them visualize what you're talking about. We're going to talk just briefly about that in a few minutes too. So keep all that in mind. But when you get in front of your jury, make eye contact, because if you can't look them in the eye, they're not going to trust you, right? And then talk with them. Don't talk at them, right? There's such a difference. There's such a difference. If you give an opening or a closing argument twice and it's exactly the same, you're doing it wrong.
Yep.
It should never be exactly the same. It's going to be similar, right? But it's always going to be damn good, but it needs to be extemporaneous.
I think that storytelling kind of like framework is really helpful in terms of talking with, not talking at, because a good storyteller is always kind of bringing the audience into this shared kind of experience of the story, right? It's not a moral lesson to be kind of like thrown at somebody's face. It's a kind of shared experience. I like that a lot. Sure.
So, from a technical perspective, you don't want to walk and talk, and you do want to make good eye contact, right? The pace of your talk needs to change a little bit. Sometimes a little faster, sometimes a little slower, louder or softer. Sometimes the most powerful words you can say are the quietest ones in a courtroom, right? So, I
think that's particularly true in in some of these kind of gaudy courthouses, like the courtroom that we have in Buncombe. I mean, it just, the space is so big, and, you know, everybody's constantly be told, you know, to speak up. And so if you really have the jurors' attention and you're saying something very quiet, it's going to really make an impact in that courtroom.
Oh, huge impact, huge impact. I'll give you an example. I was doing a demo for, I don't know, 100, 150 lawyers, and I think it was in DC sometime years ago, but I was asked to do it was actually in Indianapolis, asked to do the closing demo for them in a training program. And it started out, and, you know, there's times when you just get in a zone. You know, you feel like you're Michael Jordan. And you know, I mean, you know, it's really amazing. And, you know, it was like I was knocking them out, you know, just boom, boom. And I was just feeling great, you know, and it was getting to the end, and I had moved away from my client, and I had walked out to the audience as if they were the jurors. And I was getting ready to finish it out. And, you know, you're supposed to be personal, and you're supposed to say, you know, Jonathan Smith here. And I couldn't remember his damn name, you know, and I knew I couldn't say my client, because that would be break all the rules. You don't want to say my client. That's impersonal. You know, and I couldn't kind of walk back over to my notes and look, you know, that would be so obvious. And I'm standing there in front of all these people, and this is what's going through my head. You know, God, it's been many, many months since I've been to church. You know, but I've done a few good things for you over the years, and would you please just send me his name, you know? And the sweat's running down my back, and it seemed like forever. And I'm standing there saying to myself, what the hell am I going to do, you know? And then it came to me, and I used his name, and I closed it out, right? Well, I got back evaluations, and 8 or 10 of these evaluations said it was the most effective use of silence in the courtroom they had ever seen, right? Did you not? Nobody knew that I was crapping out other than me. So silence can be very, very, very powerful.
That is awesome.
But talking about that, a good story to use, an analogy story where you talk about coming to the conclusion and then trying to prove that you're right instead of doing it the other way around, right, is, you know, James, many, many years ago, and I think it was maybe in the 20s, the Olympic Commission decided that it was going to expand the Olympics, and it was going to include archery. And the United States didn't have an archery team. We had to assemble one like all the other countries who participated. And so we reached out all across the United States to try to find out who the greatest archers were, right? And lo and behold, there was a common thread. So many responses were, there's this guy in Colorado who is amazing, absolutely amazing. And so the Olympic Commission, you know, got together a search committee, and they headed to Colorado because they couldn't locate the guy. And they got a van, and they drove around, they asked questions, and the search got narrower and narrower. And finally they came to this country store, and they said, you know, we've been looking all over the place for this famous archer guy, and we can't find him. And he goes, well, you've almost found him. If you go up this road about 2 miles, you'll find him. Well, how will we know that we found him? You can't miss him. His barn is on the side. You'll know it when you see it, right? And so they all get in the van, they wind up this road, and they come around the curve, and lo and behold, there's this huge barn. And on it are hundreds and hundreds, if not thousands, of bullseyes. And in the middle of every bullseye, dead center of every bullseye, there's an arrow. There's not one stray arrow. Every bullseye has an arrow right dead smack in the center. And they go, this is him. This got to be the guy. They go up and they knock on the door, and there's no answer. And they call his name, and they start beeping the horn. And out of the woods comes this old coot. He says, what do you want? They said, are you John Smith? Yeah. He said, are you the archer that does this? He says, well, you're damn right I am. He says, well, we're with the Olympics, and we want you to be on our team because clearly you're the best archer out there, you know? And he says, well, that's pretty interesting. I think I'll do that. And I said, well, that's great. How did you get so good? And he says, well, you know, it's not all that hard. All you do is you get your bow and your arrow, you rear back and you shoot it into the barn, and then you walk up with your bucket of paint and you paint a little yellow circle right around. And it makes the point, because that's what the officer does so many times, is they shoot their arrow into the barn and then they proceed to paint the circle around it, as opposed to doing it the right way. Because anything is subject to interpretation, and so much of what officers do are subjective and not necessarily objective, despite what they choose to say. Right. And, this notion of based upon my training and experience is just BS. Yes. We need to know what the training and the experience is that has gotten them to that point, as opposed to just letting them sugarcoat. And, I was dealing with an officer down in Rutherford County who swore up and down that he was trained that when you pass a person at 45 miles an hour going this way, if they avert their eyes, it means they committed a crime or an right? Like, damn.
That's
we need
some high level training that nobody else got, unfortunately.
You got that training when? I can't remember exactly the course that it was in. I said, yeah, okay.
Yeah, and I think that story is such a powerful. Stories are just so powerful themselves. I mean, it just is such a great way to communicate with jurors. But I think in particular that one, if you have a situation where the officer on camera, comes up to the vehicle and, first question is, how much have you had to drink tonight? And then they basically have the PBT already in hand before they walk up from their car. They say, can you blow into this device for me? All of that then really starts to show the officer, again, isn't coming into this with a mindset of, let me just kind of find the evidence as it lies. Let me see how this person is acting in this particular situation. It's all being kind of built for an eventual DWI arrest. And now maybe sometimes when they do that, the person then blows into the device and they blow a zero and they say, well, be on your merry way. But if it's in your case and that's how they've kind of approached the investigation, that really can kind of then convey the factual underpinning for that story's effectiveness.
Sure. I think you're absolutely right. We don't see as many, and I'm not saying that all officers do this, right? There's some officers that are straight up. And, back during the beginning of my career, we had some of the old school highway patrol officers. And, we had a couple of them who were just incredibly honorable and honest. And I remember a case that I tried, and my client had come from a Pizza Hut where he was a manager, and they had been reloading the beer keg thing, and the thing had just spewed all over him. And so he smelled like a brewery.
Right.
And and he gets stopped, and the officer is like, it was a highway patrolman who asked him. He didn't say, "You've been drinking." He said, I smell a lot of alcohol. Can you tell me what's up? And the guy tells him. He says, he ends up writing him up. But when we get to trial, he says, I just got to be honest with you. He smelled like he had spilled beer all over him. It wasn't really strong on his breath. And, frankly, he wasn't so hung up on, let's get a conviction here.
Right. Exactly.
Look, common sense, and
I also think some of it is actually a little bit more systemic as opposed to kind of individual officer problems. So for instance, with regards to the PBTs, the National Highway Traffic Safety Administration program says do the PBT after you do the field sobriety test. Well, I've heard a number of officers from different agencies, including local highway patrol, just say we were trained in our training to do the PBT first and then to do. So it's not even as though they're kind of like going outside of the training model, but it actually shows like a much larger problem, that it isn't even just this officer that is kind of like looking at the investigation through this kind of result first orientation. It's their superiors and the people that are putting the training programs into place.
Mm-hmm. I think so. And it becomes really important for the lawyer then to understand why the tests are to be done in a certain order, what difference it makes, so that you can talk in very basic terms with jurors and with a witness while you're examining them about the importance of doing things in a certain way so you don't violate the bullseye rule, right?
Right, exactly.
And that becomes just critical, which then tells us that when we're cross-examining an officer, on what they did. Before you ever get to the specifics of this case, you have got to talk to them about how things should be done in general, broadly, right? Because if you don't, and you go to the specifics of the case, they'll screw you every time. And then you have to try to back out of it, right? And then go back to the general, which is painful. If you start with the general, right, whether it's report writing or whether it's testing or investigation, this is what the officer is going to say to themselves. Lindsay's getting ready to screw me. I'm not sure exactly how. It's somewhere in all of this shit that I've done. I don't know, right? If you go to the specifics, they know exactly what you're going to say they did wrong, and they'll fix it.
Yeah, that's right. That's so true. That is so true.
You shut all those escape valves, and then when you get to the specifics, they're sort of like, yeah, when did you stop beating your wife kind of question, right?
Yeah, right. Yeah, exactly.
No room for them at that point in time. So broad to narrow, broad to narrow, broad to narrow is the way you deal with officers when you're dealing with omissions, like prior inconsistent statement. They testified differently than their report, or impeachment by omission. They say something that's not in the report. Those kinds of things. You're going to talk about report writing in general?
Yes, absolutely. Yeah.
Before you get down there. And the same with any tests that they do or investigations that they do.
Yeah, that's one thing that I kind of constantly preach is lock the officers into their report before you ever start asking any question about the report itself. Go to the very broad, like you just said, and make sure that they have been trained to write, effective, very specific, detailed reports, right? That's in their training. Then did you do that in this case? Because they then now can't say, well, I disregarded my training in this particular situation. Right. So now they're going to say that. Then you ask them the questions about what's specifically in that report. Don't just start diving in, because then you give them the wiggle room to say, well, I didn't think that was so important in this particular circumstance, or why not? They've already said that it was.
And another thing you can do too is, especially if you've got two officers that are involved, one who is primarily responsible for the testing and you're being critical of, the other one who was assisting in some ways, sequester them, get them sequestered. And when you pull the one in who wasn't doing the stuff that you're really calling into question, use them as an expert witness about what you should do and why it's important. And then they disappear and your guy comes in and he says, oh, I didn't do it that way. Now you've got the one witness, the state's witness, that says this is how you're supposed to, and you got the other one saying, well, I didn't do it that way. And then you're really ahead. So you're collaterally impeaching them, and it's really a cool thing to do.
Yeah, no, it is. Yeah, I totally agree. I think that sequestration of witnesses, particularly multiple officers, is one of the most effective tools, because it's almost an impossible task to line up stories correctly, even when there is no reason to hide anything. Like even if there, everything is supposed to be, above board and the officers aren't doing, it's so difficult to kind of remember something from 8 months ago exactly as it happened and where certain things were located. It just is a difficult task, but any of those inconsistencies can come off very easily as being kind of a intentional inconsistency, or, one officer kind of trying to hide something. So that's really powerful.
And James, a big point about sequestration is that lawyers oftentimes don't ask the judge to extend the sequestration to breaks and overnight.
Yes.
Instruct the witnesses that they're not to discuss with each other until the case is complete what the testimony of the questions were. That's not what the statute says, but the judge has the authority to extend it, and all you have to do is explain, Judge, if you don't extend it in this way, then the rule is meaningless.
It's meaningless. Yeah,
it's meaningless. And most judges, I've never had a judge say, no, I'm not going to do that. The judges will always say, I think that's fair. It'll apply to your witnesses too, Mr. Lindsay. And I go, absolutely. Yeah, the zero witnesses I'm going to, right? Yeah, absolutely, Judge.
Well, I guess, one thing that I definitely kind of wanted to kind of have you talk about, Steve, in terms of, again, just being a part of the CLE that I attended with the kind of demonstrative evidence, is in terms of speaking to those jurors that are kind of visual learners or kind of need some sort of tangible explanation to kind of connect to. What kind of demonstrations or examples do you have on that front that are powerful in a closing?
Well, I think one of the things that people need to remember is that creativity is the answer when it comes to demonstrative evidence, and it's not something to wait until the last minute to do. As you start developing your theory of the case, you need to think of things visually. How am I going to show this? How am I going to be able to explain this in a way that gets through to the visual learner, to the oral learner, to the tactile learner? And all senses are fair game, right? All senses are fair game. It's not just visual, it's touch, tactile. It's what you can smell, what you can taste. All of the senses come into play, right? What you can hear. And so as you think, expand and you bring your creativity to the table, think out, I say outside the box, but think broadly and creatively about all the many ways that we receive information as human beings.
Right.
If we are claiming, for example, in an assault case, that the other side got drunk, right, and they say, well, I had 24 beers, I had a case of beer or what have not. Think about using a case of beer and setting those things on the table so the jury can visualize how much we're really talking about. You can even pop the top of one or two of them if you need to, because beer, the aroma of beer will spread pretty quickly, kind of like perfume through the air. And when you get that smell of beer going, right, it helps people visualize.
This is actually an interesting point that you just brought out, because I've actually seen officers do this extremely effectively on dash cam, right? They'll take the open containers that are in the car and just set them up on the top of the car. And once they get to like the sixth and the seventh, it's just like, I don't know how good my guy looks on video, but this is just going to be incredibly damning in front of a jury to see all this stuff coming out of the car. And it could have been drunk 4 days ago, but it just is such a powerful image of how many open containers are coming out of the car.
That's right. And I think if we think about that, and we know that that's potentially coming, and we think about the intersection of our story and their story, remember, they're now focusing their case on that intersection, that stop, and those things. And in order for the jury to get beyond that and say this guy is not guilty of anything, we need to back away, go backwards in time. And we need to be talking to jurors about how many people use your car.
Right.
How many times have you gotten in your car and there's been stuff in there that you didn't put in there and you wish wasn't there? I've gotten in my car before, and you know what? There were some beer cans rolling around in the back seat. And I was saying to myself, where the hell did my 16-year-old son come up with some beer? And why was he so stupid as to leave them in my car, right? And so, there's other reasons why those may be there other than the fact that the person who is there on the side of the road drank them and then left them in the car.
Right.
And we've got to give the jury the opportunity to understand the bigger picture and not just that point of intersection. Good points. Those visuals are very, very important. So as we think about these things what kinds of things can we do? One is this, is if we are going to refer to the breathalyzer as a machine, right? And one that is capable of making errors, right? One is we know that there's an error rate, right? We already know there's an error rate, and they'll give us that on cross-examination, right? I mean, they even round the numbers off, for God's sakes, to supposedly benefit the defendant in some ways. The intoxilizer, it's interesting. I wonder how many people know where the intoxilizers are made.
Yeah, I would assume there's very little. It is impossible to get information back from intoxilizer. We've tried to purchase a machine from them in the past, and they are very secretive about that information. So there's probably few people that know anything about that.
Again, if we think about, and I think back to a case that I tried years ago involving a Curtis Mathis television fire that burned a house down. And Curtis Mathis, their logo was the most expensive television in the United States and darn well worth it, right? Well, you had these distributors. You had to get a distributorship of Curtis Mathis. But if you had a problem with your machine and you took it, they were not authorized to fix it. They could not crack the cabinet on the Curtis Mathis.
Right.
They would give you a loaner, and then they would mail it back to Texas to get fixed, right? And so finally, we had an expert just crack the back of a Curtis Mathis TV and see what was inside. And it was the biggest piece of crap TV you've ever seen in your life. Right? It was a magnificent advertising campaign,
Yep.
but the whole thing was set up to prevent people from realizing how cheap and awful these TV sets really were, and they kept it a big secret. So there's something about hiding things like that, that if you can get out the fact that, they've got all this secret stuff going on, it also means that if we can't find out about it, the officers don't know either. Right?
Exactly.
So, talking about what's inside of this box, I don't know. Well, I don't know. Are there little mice running around in it? What's in this thing? I don't know. Have you ever fixed one? Have you taken one apart? Right? If one breaks, you can't fix it, can you? No, because you don't even know how it works.
Yeah, that's super.
How many
powerful.
officers know how the thing works?
Yeah, my favorite first question on chemical analysis is, or chemical analysts is, they'll have gone through all of their training, and I say, how many hours of chemistry is required during your chemical analysis training? It's a big fat zero, right? There's not.
But, and again, you don't have to do this aggressively like I was just doing it. I like to do from time to time what I call the Andy Griffith cross-examination.
Yes.
You go, I've got to tell you, science was just not one of my strongholds growing up.
That's great.
I'm not real good. I tell you, I'd rather have a dial phone than this cell phone. There's so many things on here I don't even understand. So we've got this box right here. And so I need to ask you some questions. Maybe you can, maybe the jurors, so does it work? I mean, does it work? And go through those sort of questions. And when an officer says, I don't know, you don't have to be rude about it, but you would expect them to. And you're setting yourself up then for your closing argument, right? To be able to talk about the machine being operated by the person who doesn't know anything about the machine, right? Doesn't know anything about the machine. I think that becomes important. And two, one of the things I think about intoxilizer is, I think they're manufactured in St. Louis. Right. And even though you may not be able to get pictures of the inside, boy, you could get a picture or two of the outside of this place.
Right. Exactly.
And I don't know how many people have been to St. Louis. Man, there's some pretty rough parts of St. Louis. So, I mean, if we could come up with some photographs of the place where they make these things that look kind of dumpy, right? This is where these things are made.
Right.
My God. When is the last time they had their garbage empty? Right? And if it looks less than professional, and then we don't know what's inside the box, it helps us be able to suggest to jurors it's just not trustworthy, right? These things aren't perfect.
Yeah, I think that's an amazing right? Analogy. And I also think kind of using that then, depending on how, just to kind of take that further out again in terms of the mechanics, you can find when the device was made, right? You can figure out what based on the specific lot number that it was given, you figure out when it was made, and then you could kind of use that to go back in time and say, well, it's made in this, in this particular factory outside of the state of North Carolina. And it's never been worked on by, a intoxilizer representative who fixes this thing. It's the Department of Health and Human Services when something goes wrong or to calibrate. So these people haven't gone to, these people don't work for intoxilizer school. So I think that is a really good way of kind of pushing that point, as you were just saying, is kind of to figure out where is this thing made? Because, when you go to, get your phone fixed, your Apple phone fixed, you go to an Apple certified dealer, right? Or you can take it to iSmashed NC, which I do a lot. But those, if something goes wrong when they fix it there, it's just like, Big
Yeah,
deal.
and when did this intoxilizer get its last iOS update, right?
Right, exactly. Right,
I
exactly.
mean, you plug it in, and does it get the updates and all this kind of stuff, and blah, 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 blah. And you can just sort of be, kind of the country stupid lawyer, who knows a lot more in the end than you want to let
Well,
on.
and I think to that point as well, it's that I think is an effective tool for attacking during closing, because you can talk to jurors about, when was the last time you purchased a computer? Does anybody here have a computer that's 20 years old? Why don't you? I mean, no, because the technology is completely outdated. But these things are sitting over there that are 10, 15, 20 years old. Obviously, they're expensive, so they don't want to have to replace them all the time. But the technology has gone leaps and bounds beyond where this finished.
It changes every hour,
Yeah.
I mean, it really does. And so as we take all of these things that we've pulled together and we move into the closing argument, which we're going to deliver in a personal way in talking with the jurors, there's some examples in life that I think that you want to bring out about machines that we all need to be mindful of, that helps bring to the point that, an 09, even when an 08 may be the limit, doesn't mean that this person was drunk because the machine could be wrong. It's obviously helpful if you've got some witnesses who are going to say, I picked him up and he was fine, and he left the bar, he was fine. You've got some video of him walking the line and he's doing a good job. He's not slurring his speech, blah, 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 right? You've got all of this other stuff that collaterally says this test isn't necessarily right?
Right.
But, we talked a lot during jury selection. This would be kind of the way I might present it to a jury about some of your experiences where machines went wrong. Machines didn't just go wrong, they created problems in your world, some more serious and long-lasting than others. Somebody shared an experience where in a hospital, a blood pressure machine malfunctioned and it seemed to be operating normally, but it didn't, and they almost lost a loved one, right? So let's think about this for a second. In our office, we have all of these computers at these different stations. And there was a day when I was at my computer, and I bet this has happened to you, where you punch a key and nothing happens. And you hit the escape key and nothing happens, right? And so you get the person in your office who's responsible and say, what do I do? And they say, well, try this. And you try this, nothing happens. You might even call the computer specialist down the road and say, my computer is frozen up. That they say, unplug it, wait a couple of minutes and plug it back in. And damn, that worked.
It does.
Right? It worked, right? What a great example of how machines go bad, right? So I think that is important. I think that reminding even today's age that if there was ever any question about how machines can malfunction, just remember the school teacher from Waynesville who went up in a space shuttle Challenger. A machine that was manufactured by the finest minds in the world, in the finest facilities in the world with NASA, and in a megasecond exploded and everybody on board was dead, right? That's a machine that never, ever, ever should have made a mistake, but it did. It did, and it cost lives. And here we have a machine that, depending on whether you choose to trust it, a machine I've not been able to ask a question of, right, or get an answer from, this man's life is going to be significantly changed. Think how important it is to be able to get to and from work, to get children to school, to visit a family member in a neighboring community who may be sick and ailing. And all of that taken away from him, and maybe go to prison too, because a machine says this. And so those kinds
that is powerful.
become important. I love to use the visual of the lungs, where you talk to the officer about blowing into the breathalyzer.
Yeah, this is one that you had used during that Henderson CLE. That's so powerful. Yeah, sorry to cut you off. I love this one.
Blow. And you got to blow, and you may even get that demonstrated in the courtroom about how hard and how often you have to blow. There's not, good God Almighty. The amount that you have to blow is incredible. And the reason is, and they tell you this, is because we need to get to the air at the very bottom of your lungs where the concentration is the most rich.
Right.
I don't know. Listen, scientifically, it makes some sense if you can think of all those scientific formulas. But in reality, it sounds like cheating to me.
Yeah. It also, the thing that I think is problematic about that is that basically you're going to be punishing people differently based on how hard they blow. So, if you have two people that both blow enough of a sample to register, but one is blowing more than the other one, they're going to have two different numbers come out of that machine. So from a fairness perspective, it's really not a good way of getting scientific evidence.
Yeah, and the way I try to show that it's cheating is I'll have a picture, a diagram, or a photo of a pair of lungs, and have a line down around the bottom showing it's way down here. That's why you blow, because this is where it's richest. That's where the richest concentration is. And then you don't bring up with the officer how cheating that is. That's a closing argument thing.
Right.
Where you set out a tumbler, a glass that you might make a mixed drink in. And you put, the bourbon in the bottom of it. And then you put some Sprite, layer it on top so that they're not mixed, And if you want to test the strength of this drink, is it really fair to go all the way down to the bottom where there's only alcohol and not mix the shit up first?
Yeah.
It's just
that's a great example. Yeah.
It's just not fair.
Yeah.
Right?
And using that, that not just like talking about it, but actually breaking out the bottle of bourbon and opening up the can of Sprite in the courtroom, I think is so much more powerful for people to see that specific example. Again, the smell and everything else coming from the bourbon is just such a powerful thing.
It is. And practice it in advance, because it's not as easy to layer these things out as you would think. Pouring it over the back of a spoon so that it won't mix. Or you don't, even if you can't get it to work that way, use oil and vinegar, because they will layer out, so you can pretend like, but you can at least show the different layers and get the jury to visualize how this just doesn't seem fair to me, right? And so those are all good things for you to be able to do during your closing argument. I think it's sincerity on your part is important, being able to tie in to your story of innocence, how this could be you or a family member who is facing a charge like this based upon slender evidence is important, and then in being very, very clear with the jury about what you want them to do and expect them to do before you sit down. Don't be wishy-washy, be direct and let them know, you're going to go back and deliberate, and based on this, you must find this man not guilty, right? Say it strong. And I think that even though a lot of our closing is extemporaneous, what we end with needs to be memorized. You need to know it's solid. I've heard too many lawyers get up there and say, so ladies and gentlemen of the jury, what I'm asking you to do is I want you to go back and find him innocent. And when you get back there, I want you to talk about it and find him not guilty. And the reason and it goes on and on and on.
Yes.
You need to hit that final point. Boom.
Yes.
And then sit down. Right. And then sit down. So anyway, those are kind of some of the thoughts that I've
Steve, it's been an incredible conversation. I think that all of those kind of practical points, in addition to kind of the storytelling end of things and how you bring in kind of demonstrative illustrations of these specific stories into the jury room for those visual learners, or into the courtroom for those visual learners, is so important. But all those practical pieces too are so helpful. So I definitely would love to have you back on the podcast at some point to talk about demonstrative evidence during trial, because I know that you've spent a lot of time on that front as well. But certainly appreciate all of the insights into closing arguments when it comes to using these visual aids and how to kind of deliver the argument.
Well, James, I appreciate you asking me to do this. I want to just add one final thing for lawyers out there. I don't like to hear lawyers say, when you say, well, what kind of closing are you going to give? And they say, well, I do this thing. I've got this canned one I do on this or on that. Don't do a canned closing. Don't do a canned opening. Your clients deserve uniqueness and individuality. There are no two cases that are exactly the same. If you will take the time to fashion both an opening and a closing that are unique to your client and the facts of the case, you're going to win more cases. When you bring something canned to the table, you're not doing what you're capable of doing. You're not bringing your A game. You're just doing things at the last minute because you may be overworked. But if you take the time, it will pay dividends.
Yeah, and I think that in terms of both opening and closing and presenting things in a story framework or using story examples in your closing, you have to spend a lot of time practicing stories. Stories are not facts, right? It's not something that you can kind of memorize just by kind of quickly getting the necessary information. Certain words and pauses and emphasis has to be kind of memorized, right? This is a stand-up routine, right? I mean, it's not comedy, but it's got to be delivered in a specific way. Otherwise, people in the audience aren't going to be, in the case of the stand-up, laughing, but in the case of us, kind of paying attention and kind of even understanding what it is that we're trying to convey.
I do a training program every year in Dayton. We didn't do it last year because of the pandemic. And there's a great restaurant there called El Mason. It was started by a family from South America who bought a pizza place, and then they turned it into a South American restaurant where they serve tapas. And it's fabulous food. And so every year we go several times while we're in Dayton. The son, who's the maitre d', has become a great friend. And I asked him, I said, I love your food. I'd love to meet your father because he's the chef. And he says, well, he doesn't speak any English, but come on back and I'll introduce you to him and I'll interpret, right? So he takes me back to the kitchen, and I said to him, I love your food, and that gets interpreted, and I don't want to offend you, but I love to cook, and would you share with me some of your recipes? And he says, recipes? Are you kidding me? Recipes? Chefs don't use recipes. He says, dude, when I prepare a meal, it's based upon texture, it's based upon taste, it's based upon aroma, and it's based upon what I have in my refrigerator at the time. It will never, ever, ever be exactly the same twice, but it will always be damn good. And that's what an opening and that's what a closing argument are supposed to be. It will never be exactly the same if you do it more than once. It will always be damn good, though, right?
I love that.
So that is a great analogy to what we do.
Yes,
right?
it is.
A memorized speech. We talk with people, and the moment drives us. We know what we need to accomplish, and we will know when we get there with the people because we're interacting with them. They are sharing their body language and eye contact with us. We will know when we have concluded that chapter and it's time to move on, and we will never do it exactly the same twice, but it will always be damn good.
That's great. That's great. I love that, Steve. That's a great story and a really good analogy to what we do. So I appreciate all of the information, all of the advice. Thanks for sharing your wisdom with the audience.
Thanks for having me, James. And until our paths cross again, which I hope is sooner than later.
I hope so too.
All right. Thanks
Talk to you
much.
soon. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.